Ms. Cheryl Chan.
Mr. Deputy Speaker, against the backdrop of changing demographics and in the spirit of digitalizing the public service, enabling the lasting power of attorney to be made electronically is indeed a welcome move, for it allows greater efficiency and convenience for the donor, donee, and the ministry. Whilst in the process of improvement and advancement, it is important that we do not forget there are risks involved. Hence, I seek clarity on the safeguards put in place and its adequacy, as well as some clarifications regarding specific sections in the amendment bill. First, ensuring robustness of the nomination process to prevent fraudulent nominations. To provide additional safeguards for donors, it was mentioned that the public guardian may interview the donor and disclose to the donor the number of LPAs for which his or her prospective donee had already been appointed or intends to be appointed. Could the ministry provide more specifics on the process and how in doing so would prevent fraudulent nominations and avoid conflict of interest for donees with multiple appointments? Further, how would the process account for and act as a preventive measure for those who are already experiencing an early onset of dementia or individuals with special needs? Regarding the process robustness, for Section 10B, subsection 1G, and Section 46, subsection 2B and D, could more clarity be shared on A, what circumstances and considerations would allow for the disclosure of this non-confidential information? B, who would be allowed the access to this information? And C, will there be any measures in place to ensure that only those permitted have access to the information and that the risk of incorrect disclosure is minimized or even eliminated? And under Section 10C, subsection 2, if more insights can be provided on what the public guardian foresees and hypothesizes that could constitute valid reasons, besides the physical disability and electronic transaction system unavailability that's already outlined, for transactions that can be carried out in the form and need not be done electronically. On Section 10D, subsection 1 and 3, in the event that the public guardian has to correct any error or omission in the register or document as a result of the malfunction of the electronic transaction system, would there be any prompt communication to inform both the donor and donee of the correction that has to be done? If so, what would be the service level agreement in informing both the donor and the donee? This is a critical point as outlined in subsection 3 that, and I quote, when an error or omission has been corrected, the error or omission is treated as not having occurred. Unquote. Should there be an error made by the public guardian in the course of rectification, what possible recourse can the donor or the donee pursue? Second, to ensure sufficient reach and provision of support for the move towards electronic LPA. I think a few of my fellow colleagues have already spoke about this, but I just want to emphasize on one point. With more elderly in Singapore living alone, are there any concrete plans to assist these seniors to file for LPA if they've not done so, and to assign deputies earlier to them to better support them in their later years? I believe many of these seniors and the special needs individuals may also be unfamiliar with the legal considerations. So how can we actually better serve their needs as we pivot towards the electronic LPA? In Clause 7, amendment of the Section 13, subsection 10, would steps be taken by the public guardian to authenticate the certificate from the registered medical practitioner, ensuring that it is a true copy? Because as we go electronic in many of this documentation, sometimes inevitably there could be errors or there could be gaps. So if we're not going to do this, how can the public agencies or organizations in which the donee is interacting on behalf of the donor be assured that there is a validation process in place? And on Section 33A, subsection 3 and 4, could greater clarity be provided on the next step of action should the donor or donee raise objections to the proposed rectification or update of the register? Last but not least, the cost that's involved and the transition process towards electronic LPA. With this move towards electronic LPA, will there be any additional cost for the donor in the LPA filing as compared to the non-electronic LPA? Because in Clause 9, Section 15A, it mentions that if there's any error to the non-electronic LPA, rectification can actually be made on the electronic version. So my query is, what then would become of the non-electronic LPA? Will it be superseded? Additionally, what is the transition process for the existing non-electronic LPA filed and the impact that it has on the existing protocols related to it? Sir, the move towards digitalization of public records is an important milestone. It will help with improving efficiency of processes for records checking and cross-usage amongst authorities, and I believe this is a very welcome move. However, LPA is a sensitive document, and it deals with the matters that affect the welfare of the citizens, particularly more so for the vulnerables. Thus, it is important that we maintain a robust system, albeit electronically, which manages the affairs with great accuracy and continues to uphold the trust between the institution and the public. Notwithstanding my clarifications, I support the bill.